Continuing from the discussion on advertising requirements and the role of the public report, it is critical to understand how Arizona law protects buyers after they enter into a purchase agreement, particularly through the statutory right to rescind. This right functions as a safeguard that ensures purchasers have an opportunity to review the full details of a development or property before being bound to the transaction. Arizona law distinguishes between improved lots, those with completed structures or ready for occupancy homes, and unimproved lots, vacant or undeveloped parcels. And the rescission periods differ depending on the type of property involved. The statutory framework for these rescission rights is established under ARS Section 32-2181, ARS Section 32-2183, and ARS Section 32-2195.03, with additional guidance found in Commissioner's Rule R 4-28-802. Together, these laws define how and when a buyer can cancel a contract without penalty, and what duties brokers and licensees have in ensuring the buyer's awareness of these rights. For improved lots, typically those with completed homes, model homes, or new construction that is habitable at the time of sale, the buyer's right to rescind is limited and hinges on the timely receipt of the public report. Under ARS Section 32-2183, a buyer must be provided with a copy of the public report before signing the purchase contract. If the buyer does not receive the report prior to execution, the purchase contract is voidable at the buyer's option. This means the buyer may cancel the contract without loss of earnest money or penalty. However, once the buyer acknowledges receipt of the report and proceeds with the transaction, the contract becomes binding unless other conditions, such as contingencies, apply. For example, imagine a buyer purchasing a newly constructed home in a planned subdivision in Gilbert. The buyer signs a purchase agreement at a model home office, but is not given a copy of the public report until 2 days later. Upon reviewing the report, the buyer discovers the development is subject to a $3,000 annual HOA assessment not previously mentioned. The buyer immediately notifies the builder and cancels the contract. Under ARS Section 322183A, the cancellation is valid because the buyer did not receive the report prior to contract execution, and all funds must be refunded. In contrast, unimproved lots, defined in ARS Section 32-2181E, as land with no completed residence or building intended for occupancy, are subject to additional rescission rights designed to protect consumers from making uninformed purchases on undeveloped land. According to ARS Section 322-195.03, buyers of unimproved subdivided land located in Arizona have 7 calendar days after signing the purchase contract to rescind it for any reason, provided they notify the seller in writing within that period. If the land is located outside Arizona, or if the buyer did not have a chance to inspect the lot prior to signing a contract, the buyers are granted 6 months from signing the contract or receipt of the public report, whichever is later, to cancel, as outlined in ARS Section 322195.04. This difference reflects the higher risk associated with purchasing vacant land, where issues like access, zoning, water availability, and development feasibility may not be immediately apparent. The 7-day cooling-off period allows buyers to reconsider, conduct due diligence, and confirm that the investment aligns with their expectations. Consider a buyer who purchases a 2-acre unimproved lot in northern Pinal County from a developer who just received a public report. The buyer signs the contract on Monday, but learns by Friday that the property lacks a reliable water supply and will require a costly well installation. The buyer sends written notice of cancellation on Saturday. Within the 7-day statutory period, the seller must refund the buyer's earnest money, and the transaction is terminated without penalty. Had the buyer missed that 7-day window, the right to rescind would have expired, and the contract would remain enforceable. Licensees play a vital role in ensuring that their clients understand these rescission rights and act within the allowed timeframes. Under AACR 4-28-1101, a licensee must deal honestly and fairly with all parties and disclose all material facts, including statutory rights. Failure to explain a buyer's rescission right could result in disciplinary action under ARS Section 32-2153 for negligence or unprofessional conduct. Brokers must also ensure that all contracts used in new home or subdivision transactions contain language outlining the buyer's rescission rights in accordance with state law. Additionally, ARS Section 32,218.03 governs lot reservations, which are agreements allowing buyers to hold a lot before a public report is issued. In these cases, the buyer must be informed that the reservation is non-binding, and any funds collected must be placed in a neutral escrow account. Once the public report is issued, the buyer must receive it before converting the reservation into a purchase agreement, at which point normal rescission rights apply. Example scenario: a developer in Maricopa County begins taking lot reservations for an upcoming subdivision called Coyote Ridge before ADRE issues the public report. Buyers pay $1,000 deposits to hold specific lots. When the report is issued 2 months later, one buyer reviews it and discovers that utility connections will not be available for another 18 months. The buyer decides not to proceed. Under ARS Section 32,218.5.06 and ARS Section 32,281.03, the developer must refund the full deposit because the reservation was non-binding until the public report was received. Review summary: Arizona law distinguishes between rescission rights for improved and unimproved properties. For improved lots, the key protection is the buyer's right to cancel if they were not provided a public report before signing the contract. For unimproved lots, buyers are granted a statutory 7-day right to rescind for any reason. Out-of-state subdivided land purchases carry a 6-month rescission period. Licensees must clearly explain these rights, ensure timely delivery of the public report, and maintain documentation of buyer acknowledgement. These provisions uphold Arizona's consumer protection framework and reinforce trust in new home and land transactions. Discussion prompts: why does Arizona provide a longer rescission period for unimproved land compared to improved properties? Answer: because unimproved land carries greater risk and uncertainty, allowing buyers additional time for due diligence before being bound by the contract. What is the buyer's remedy if they were not given a public report before signing a contract for an improved lot? Answer: the buyer may void the contract and receive a full refund of any earnest money paid. What must a licensee do to ensure compliance with rescission requirements? Answer: verify that the buyer received the public report before signing the contract and inform the buyer of their statutory rights to rescind. Closing remarks: the right to rescind empowers buyers with confidence in one of the most significant financial decisions they will make. Whether purchasing a new home or raw land, Arizona's rescission laws guarantee transparency and fairness. By allowing buyers time to review disclosures and reconsider their decision without fear of penalty. For real estate professionals, honoring these rights is not just a legal obligation. It is a demonstration of integrity and ethical practice in every transaction.